Thank you, Madam Chair, and welcome, ministers. Thank you very much for being here to take our questions. As you know, senators and indeed all Canadians care very much about this issue, and your time is greatly appreciated today. I want to quote briefly from a letter I received to give voice to this viewpoint and get your response. The writer says, "It is wrong and unconstitutional to continue to exclude individuals with mental disorders from equal access to the law. People across Canada who have been suffering from mental disorder that cannot be relieved under conditions they find acceptable should have the same right to autonomy and choice as individuals with grievous and irremediable physical conditions." What would your response be to this Canadian?
So thank you, Senator Cardozo, for the question. And obviously the constitutionality has been at the heart of the MAID discussion since the Carter decision was rendered back in 2014, 2015. What I would say to that individual is that when you get at the heart of an equality analysis under the Charter, you look at whether you're perpetuating negative stereotypes or attacking or impugning the dignity of the individual. Here, I have said, Minister Holland has said, our government has said, there is an equivalence between mental suffering and physical suffering. There's no daylight between those two. Secondly, I would say there is no perpetuation of a negative stereotype about the decision-making capacity of an individual who's mentally ill. What there is, however, is an appreciation of the complexity of applying determinations about capacity and decision-making in the context of people who are struggling, who may be making a request in a time of crisis that has to be distinguished from a considered and reasoned application of MAID, and where suicidal ideation can enter as part or a feature or a symptom of someone's mental illness. We have to make extremely sure, we have to be absolutely sure that people who are doing the assessments have the ability to distinguish what is a symptom of a person's condition versus what is a reasoned request for MAID. It is deeply complex, and I would actually say to Senator Wallen, if I had had the time, that even it's not just that MAID is different from what general healthcare practitioners do. Providing MAID in this context is substantively different, qualitatively different than any other context that's being provided. So are there charter issues at stake? Absolutely, the charter is at stake. But what I believe firmly and what is reflected in that charter statement is that we have to make triple sure that we've got the rigorous assessment and training that are in place so that people can make that evaluation. And it's critical to get that evaluation right. I don't think the Constitution mandates me or our government to provide a service, in this case a healthcare service, when it is not safe to do so. And that is our determination that it is not safe at this time.
Thank you. I do appreciate your keen arguments about the Constitution. My other question is just why 3 years? A year ago when your predecessors before us, they'd asked for 1 year. Why did you not pick 1 year or 2? Why 3?
I think it's important that we, in terms of this timing piece, and this came up with the interaction with Senator Wallen as well, is that what we're trying to do is reflect what we've heard from healthcare providers. We're trying to ensure that we're not repeatedly back in front of this chamber or in front of the House of Commons, continuously seeking extensions. We're looking at the roadmap that is in front of us in terms of having a sense of when we will have a better understanding and appreciation of the development of further mechanisms. And one thing that hasn't been elaborated upon here is that a critical component is back-end oversight and analysis and case reviews. My understanding, and Minister Holland will correct me, is that it's only the coroner's offices in Quebec and Ontario that mandate a review of such cases have made across the board. We want to see rigorous application of such oversight processes as well as rigorous take-up, and we understand and we feel confident that within 2 years' time, a joint committee made up of senators and MPs will be able to evaluate that, and within 3 years' time, we'll be able to go ahead. But having a back-end timing window ensures that people continue to do the work that is necessary, and that's critically important.
Thank you.